I beg your lordship, pardon my lord. This is a bail application in a criminal appeal. The appellant, next week I pray.
Lord, there are three tied up matters. Please give it. I have been mentioning regular. Please give it.
Criminal appeal, my lord.
Give.
Okay.
Lord, on bail application, my lord.
My lord.
Give it.
Lordship, may I mention one matter, Lordship?
Against the order of acquittal under NI Act, my lord. Yes, it is.
Give it.
My lord, petitioner is in custody since 2.5 years. I is filed for his
Bail.
Bail.
Give it. Yes. You are not audible. You are not audible.
Yes, Lordship, there is appeal, criminal appeal 8715/2018. I have filed the IA for bail. Lordship, he is in GC for more than 6 years.
Okay. Note it down. It will come next week.
I'm obliged, Lordship. I'm obliged, deeply obliged.
May I pardon, my lord? Item 246, my lord. Case of conviction by the vigilance court, my lord, 4 years conviction. In custody, my lord, and it come in orders, my lord, there is no defect. Copy has already been served, my lord.
No, Vigilance Council is here.
Sarthak Naik Japping for, I'm sorry, CBI, my lord, Naik is appearing, my lord. Sarthak Naik Japping for CBI, my lord.
Oh, not Vigilance?
No. Okay. Vigilance case is convicted.
Ask Mr. Naik to join, I can take up. Yeah.
But today, if possible, my lord.
अरे तांको जଣା उसी पास सिलो I have no.
Publish.
Weekly list item number item number 2.
SI for 1 year, my lord. Or 324 items.
Page, relevant page is
31, my lord.
running page or internal page?
Running page, not internal. Running page 31, judgment to 25, last para 27. I am to consider opinion that expended interest of justice to sentence the convict to suffer simple imprisonment for 1 year.
You are on bail during the polite. Admit you are on bail granted.
Item number 3.
Please, my lord. Running page 75, my lord. Internal page 63, running page 75. Convict Prakash Malik alias Kalia is hereby sentenced to undergo RI for 4 years and pay fine 5,000 in default, RI for 3 months, my lord.
Convict?
Convict Prakash Malik alias Kalia.
Okay, this appeal has been filed by Prakash.
Yes, my lord.
Okay, sentenced to undergo RI for 4 years.
4 years, my lord.
Fine is 5,000.
My lord.
In default to undergo so and so.
Yes.
So you were on bail during trial.
Yes, my lord. Yes.
Co-accused CRLA 797 of 2023 has been admitted by your lordship on 24/7. LCR has been called for in that
797 of 2023.
Yes, my lord. 797 of 2023.
All right.
by Chitaranjan Behra.
All right. Admit bail granted. Sterilization fine. It will come henceforth along with CRLA number 797 of 2023. Mr. Sanjay Das Lenin, Standing Counsel for the Vigilance Department, will file the appearance memo
By the end of this
month, and free copy of the order be handed over.
Item number 5.
by
Conviction under section 7 and 13 to reduce
Operative part.
internal page 24 of
Internal page 24.
sentence
Just a minute.
3 years.
3 years, 20,000 each for so and so. In default of fine. Okay. Concurrently. So it is 3 years. And you are on bail during trial.
Yes, sir.
Yes,
As
Mr.
well.
Das.
yes, ma'am.
All right. Admit bail granted. Sterilization of fine. Same order like item number 4. You will file the appearance memo. By end of this month, free copy of the order be handed over to Mr. Das. Yes. Next.
All right.
Item number 7.
May I please, your lordship?
Yeah.
Appeal against a conviction of the appellant faced trial and has been convicted under section 307 for 10 years, my lord.
Page relevant
Page
page is
48, running page 48.
running page 48.
During trial, he was on a bail, my lord.
Wait. Convicts are sentenced to. Okay. RI for 3 years under 2332. RI for 2 years 353. Then RI for 10 years 307. And fine. So the maximum one is 10 years. That is under 307.
Yes.
So okay. Hard admit call for the trial court record. Interim applications for bail and stay to be considered after receipt of the trial court record. Deposition copy be supplied to the Learning Council for the state. Yes.
During trial, he was on a bail, my lord.
Keep the copies, let the
Item number 8.
May I please, your lordship, my lord, operating part of judgment, my lord, that is running page 40, second paragraph.
40 page.
For offense 21B, 3 years imprisonment and 30,000 fine is there. And I was also on bail, my lord.
Sentence for 3 years, 30,000 in default. 21B. Okay. So you are on
Bail, my lord.
bail.
paragraph 4, my lord, of my 3 of my
That's
bail
all right.
application. On
Yes, Mr. Das. All right. Admit he was on bail, bar under section 37 not applicable in view of the quantity of brown sugar seized. So, bail granted, sterilization of fine.
obligation.
Item number 9.
May I please, Your Lordship? Lordship, the appellant is convicted under Section 7 of the Prevention of Corruption Act, Your Lordship. The relevant part at page 64, Your Lordship.
64,
Your Lordship.
Okay. It is RI for 3 years. Fine of rupees 5,000 in default. RI for 3 months under section 7 of the PCA. Okay. You were on bail.
Yes, Your Lordship. At
Yes,
page
Mr.
50.
Das.
Yes, ma'am.
All right. Admit. Bail granted. Sterilization of fine. Rest of the thing like the previous 2 orders. 3 copies to be given. Yes.
3 copies.
Yeah.
Also, in item 12, the appellant has convicted under section 7 of the Prevention of Corruption Act, your lordship. The relevant part at page 49, your lordship.
49.
Yes, your lordship.
This name is, what is his name? Bhavagrahi Samantroy. Okay, sentenced to undergo 3 years, 5,000. In default undergo so and so 7 of the BC Act. Okay. Yes, Mr. Das.
Yes, my lord. My prayer before your lordship, item 10 and 12, the registry should be directed to mention vigilance, state of Orissa.
All right, Honor.
So we are confused.
All right. See, he was on bail, so admit, bail granted, stay realization fine, free copy, and Mr. Das will file the appearance memo by end of this month. Henceforth, since it's a vigilance appeal, the after state of Orissa vigilance, the word vigilance shall be mentioned in the cause list as well as in the top of the brief.
Item number 10 also.
10 and 12, yes.
Obliged.
19.
Please, Lordship, pass over. I'm for the informant.
Oh, okay. What is the offense here?
My Lord, here convicted 307, relevant page 24.
300?
307.
What is the sentence imposed?
Sentence, my Lord, say acquitted also. On the next page, my Lord, page 24.
What is the relevant page of the where the sentence pass is stated?
Relevant page 25.
Okay.
Last person. Arrive for 10 years. And
You are Rakesh Parida.
Again.
10 years under 307.
Again. And in the page 24, my Lord, he was acquitted 341, 294, 326 IPC, reduced with 30 of the.
Who is that injured?
Injured, my Lord, P5.
Have you given the deposition copies?
Yes, my Lord.
I received deposit copies, but so far the P 5, 6, and 7, the injured and other, those are not the certified copies. They are only
5 and who is the doctor?
Yes, sir. Two doctors are there. One is the doctor in my Lord, that is P7, the doctor on behalf of the prosecution, and a D11 is the doctor. Is a special.
Trial court record
two doctors are there, man. And two differential few are there. The matter is not sent to the medical board for a.
PW7 is one of the doctor.
My Lord.
I examined Vishwa Prasad Mahanti, son of so and so. He was brought to the hospital by his father. On examination, I found the following features. So, incised wound is there, fracture is there, bleeding incised wound, X-ray of the elbow indicates fracture. So, what is the weapon of offense?
Weapon of cutlery, but that are not seized, my Lord.
How many blows you have given to this man? 1, 2, 3. It's more than 5, 6 blows you have given.
Yes, my Lord.
And X-ray indicates there is fracture. So
left hand is already amputated.
Huh?
Left hand is already amputated.
Amputated.
Yes, sir.
So since how many years you are in custody?
My Lord, 2 years in custody.
2 years in custody. And what is your criminal antecedent?
No criminal antecedent.
Yes, Mr. Das.
My Lord, I have not received, my Lord.
The Lieutenant Counsel for the state seeks some time to obtain instruction about the criminal antecedent, if any, against the appellant, and shall also produce the health condition report of the injured. So also his photograph. It is stated at the bar that one hand of the injured has been amputated due to the occurrence. Put up this matter on, give a date after 1 week. Yeah.
My Lord, on a specific date, my Lord.
Yes, next.
Item number 20.
May I please, Lordship? Lordship,
Yeah.
last occasion, Lordship ordered that to file a comprehensive affidavit regarding the criminal antecedent of the present petitioner, Your Lordship. So we, in the meantime, we apply for the certified copy for the.
What do you want? Do you want adjournment?
Yes,
Okay. The Land Counsel for the appellant seeks for an adjournment. Yes.
IA number 1535 of 2023 is for stay of conviction, my lord. The appellant has been convicted under section.
May I pray, my lordship, matter to be taken up next week. I have filed my objection in this case.
Objection already
Yes,
filed?
yes, my lord.
Okay, copy has been served.
Yes,
on-
yes. My lord,
What is the offense here?
31
31.
he has been
Disproportionate asset.
disproportionate asset, my lord.
What is the asset, disproportionate asset?
1 lakh. Your lordship may kindly come to page 49.
49.
My lord. How it is erroneous, your lordship may kindly see it.
No, no. What is the ultimately?
1,06,000.
Mr. Das.
Yes.
Can this be a disproportionate asset case? 1 lakh. Some person will every day he will just.
No, that is not the illegality. Illegality is less than 10%. Can a person be convicted less than 10%?
Yes, yes, sir.
Yes. What you say?
My lordship, in Joy Lalita case, it has already decided.
Forget about.
No. Why forget about?
You are comparing Joy Lalita case to a 1 lakh.
When in Joy Lalita case, it is 8.2%. And that Agnihotri case, my lordship, it has been dealt with in that case, my lordship.
Somebody is in disproportionate of rupees 1 lakh.
Yes,
how many, what is the period of service you have taken a check period?
So entire period, service period, that is about
93 to...
93 is the date of search.
Yes.
So his entry into the service is
65 to 93.
65.
And is it? Can you tell that what is your monthly income and what is the expense and how much you saved each month? Are you keeping all the details? Each time you are spending something, you are keeping the details.
My lordship,
Is it possible? Is it possible?
No, my lordship.
So
that has also
1 lakh is an amount for which you will file a disproportionate asset case against somebody, and years together you will pass.
While this case was initiated, it was 9 lakh something, 9,33,000 was the DA. And
I'm not telling you. Question is that now you found that it's a 1 lakh case. So this man has already lost his service.
Yes, he has already.
It must have been dismissed from retired. Okay.
Retired man.
So if you are retired, then how this?
My provisional pension has been stopped for May 2023. That is the only mix of
by staying conviction, your provisional pension, they will give you the full pension. Is it the rule? Give the judgment. Let us see.
No, provisional pension.
No, provisional.
What I was getting.
Provisional pension has been stopped.
Yes.
So to find out the law on that.
My lord, your lordship, kindly for a moment, your lordship, kindly come.
No. Come. What is the outcome? You have been granted bail.
No, that is the 1,06,000. That is also not honest. Your lordship, kindly come to page 40.
That is the merit of the.
Yes, that I am bringing to the lordship's court.
No, it's all right.
Kindly come to page 40.
No, it's all right. That is one aspect.
No.
In what way?
For a meaning, your lordship.
In what way this stay of conviction will give you benefit?
No, because
you are now retired. You are. This is your difficulty now. You are facing. You are not getting pension. Show me a decision that the stay of conviction will allow you to draw the full pension or at least provisional
my
pension.
humble submission is that before conviction, I was getting the provisional pension. If that,
I'm telling you, give me the law.
My lord, I
next week.
Your lordship, kindly for a minute.
It's all right. At a time. No piecemeal manner. This is IN number 1535 of 2023. It's an application for stay of conviction. Learning Senior Standing Counsel for the Vigilance Department, Mr. Sriman Das, has filed objection to the interim application. However, he seeks for an adjournment till next week, and it is stated at the bar that the petitioner has already retired from his service. Mr. D.P. Das, Land Counsel for the appellant, submits that the petitioner is not getting any pensionary benefit. When a question is posed to the Mr. Das that what would be the outcome of stay of conviction, whether the petitioner would get his pension, or at least provisional pension, in case of stay of conviction, he seeks some time to search out the citations on this point, put up this matter next week. Yes.
Item number 25.
Copy of the order be handed over to Mr. Das.
Yes.
You also find out the decisions.
Yes.
25, my lord.
Item number 26.
Please, my lord. The IA is for stay of conviction.
Yes.
Appellant before your lordship, my lords.
Objection not filed?
Yes.
You filed?
Objection has been filed since 18/7 first time
Yes, served a copy.
and on 24/7 second time.
Okay. So what is this conviction, Mr. Panda?
Conviction is under the PC Act, my lords.
Under what is the PC Act? That means,
Your lordship may see the impugned judgment at running page 2, my lords. The details of the sentence imposed arrive for 1 year, fine of rupees 2000, in default further arrive for 2 months under section 7, and arrive for 2 years, fine of rupees 2000, in default further arrive for 2 months under section
it's a trap case.
Yes.
Yeah.
Now, at the trial, my lords, the complainant was dead. So his evidence is not there on record. The overhearing witness, my lords, is PW2. And the trial court has discussed the evidence of PW2 at paragraph 11 of the judgment, my lords. Your lordship may look at internal page 20 of the judgment. Now, the trial court has held that the evidence of this PW2, it establishes demand as well as acceptance, my lords. And
come to paragraph number 11 you are referring?
Yes, my lords. Now, so far as the first part of that para 11,
yes,
we are not concerned because that is relating to his arrival and the preparation report, my lords. Your lordship may look at page 22, para 11A. PW2 has specifically deposed at para 4 of his evidence that we noticed the accused was available in front of the room of the vice chairman, that on seeing the presence of Millu Rai / informant, the accused called him and inquired about the money, and that on receipt of positive indication, complainant had delivered the amount after collecting it from his shirt pocket, and that accused collected money by his right hand, counted by both hands, kept it inside his pant pocket. This evidence in chief, my lords, is relied upon by the trial court to hold that demand as well as acceptance have been established by the overhearing witness.
Yes.
Now, while holding so, my lords, the trial court has very intelligently avoided one sentence which is a very material sentence brought out in cross-examination at paragraph 10, my lords. There he has stated specifically in cross-examination that I cannot say the exact verbatim of the conversation between accused and the complainant. This part the trial court doesn't deal with, although in para 11B,
PW2 paragraph number?
That aspect, my lords, this evidence of PW2 at para 10 of the cross-examination, that has not been dealt with at all by the trial court in the judgment at para 11B, where he speaks about the evidence of PW2 and about his cross-examination. He has referred to other paragraphs of the cross-examination, that is paragraph 8, paragraph 9, but he doesn't refer to the evidence recorded at para 10. What he says, like this last part, my lords may see, page 23. At para 10 of his cross-examination, this witness has further deposed that the complainant removed the money from the fourfold paper on the veranda itself, and I gave signal. This part he records, but the other part of that paragraph 10, that I cannot say the exact verbatim of the conversation between accused and complainant, that has not been recorded also in the judgment.
But what he heard from the, or she saw it?
Yes, in chief, my lords, it is stated para 11A, my lords.
No, chief examination?
At para 11A of the judgment that is quoted.
No, judgment. I'm telling about the evidence. Let us see.
Evidence, yes, my lords, I am just pointing out. He has stated like this in the examination in
Paragraph 4, you come out.
Yes, my lords, para 4. Fourth line, my lords. On seeing the presence of Milu Rai, accused called him and inquired about the money, and on receipt of positive indication, complainant delivered the amount after collecting it from his shirt pocket. So this evidence, my lords, at best it says that there was an inquiry about the money. It does not establish demand in so many words, my lords. And then he says, thereafter accused left towards the office of ICDS, I relayed the message. And then he speaks about the detection. Now, dear lordship, look at paragraph 10 of the cross-examination. The first line of paragraph 10 is, I cannot say the exact verbatim of the conversation made between the accused and the complainant. This, in my respectful submission, my lords, is an important piece of evidence.
No, what he means to say that in gist, this is the thing which the
Exactly, my lords.
accused, but exactly that means the word by word.
My lords.
Maybe the cross-examination, defense counsel must have asked the witness कौन कौन कहले आक्षरिक भाव रे कहि परिबो कि से तळ कहबो आगे या नै से कहबो हां
जे आपणको उपस्थिति रे से किछि टंकाटा को मागिले कि
नो दैट इज ए से जनरल जिंसटा रहिछि बट आपण जेतबेले कहिबे पूरा आक्षरिक जहा कहले से कोन आगे आक्षरिक मु कहि परिबिनी बट एया तांको कहले बस बाजे
तो न हो भी मोर
एग्जैक्ट verbatim what I mean it means that जहा से कहिले
वो सबमिशन हो जाएगा. This has to be read along with the evidence in chief. Chief रे आगे से कहला कोन accused called him para 4 रे कहला.
But Mr. Panda, there is a recent decision. Suppose the other parts are there. This acceptance and recovery part is there, and some kind of your gesture indicates that you demanded the money. So then can also that demand part is not there. Somebody should
exactly
say that.
My submission is that even if we read paragraph 4
once
again also, there is nothing to show Millards that there was anything indicating that he demanded the money.
No.
And my defense plea is that he was a tutor of my daughter, and he had taken money from me, which he was to refund, and he had refunded that money. That is my defense plea. Another aspect your lordship will find.
Now, what is your position? You have been dismissed from service.
I apprehend that I will be dismissed from service.
You have not been dismissed. Okay.
I have annexed the annexer A.
I have not received any of
annexer
that.
A may kindly be produced.
Annexure
A. I have served the copy on my learner.
Yes, I have got that copy.
Page
but
10, 11
just a minute, let me see.
I have inquired from my client. He says that he has not received.
What is that objection?
flag
Huh? वो अभी तो रची बड़ा स्कैन ही नहीं. Yes, it has been dismissed from service.
Original copy I am submitting your
not served on me.
Original copy.
No. Why have you not served a copy?
Yes, I have served the copy.
No, she has served a copy.
Yeah.
But the government, my department has not yet served that.
Department, your lordship may kindly have a glance to page number 12.
Panda copy to lekha है जी सब.
Copy to
page 12.
received.
Page 12 रे copy in duplicate forwarded to the block development officer Nuaga.
Okay, we'll
Now let
consider.
us accept, Milords, that I have been dismissed.
Now,
I
what
don't
benefit we'll get? Suppose there is stay of conviction.
Yes.
Let us say
Yes.
stay of conviction. Can on the basis of that they will restore you in this?
They can.
Please show me the decision.
And I'll have to take an adjournment.
Okay. The learning council, but also take the further instruction what you are telling that you have not been served in person that. Okay. Mr. Devasis Panda, Land Council for the petitioner. Acha, when Mr. Das, Land Council, Vigilance Council, Standing Council for the Vigilance Department, pointed out from his objection file that the petitioner has been dismissed from government service. The petitioner, who was the VLW cum Panchayat Executive Officer, Chamundia Gram Panchayat of Gonia block, and at present Panchayat Executive Officer Nuaga block in the district of Nayagarh, has been dismissed from government service. Mr. Panda on instruction submitted that the copy of the dismissal order has not yet been served on the appellant, and he will file an affidavit to that effect. Stop. When a question is further put to Mr. Panda that since the appellant has been dismissed from service, whether the stay of conviction will be sufficient to get back the service. They seek some time to find out decisions on that point. Put up this matter. Next week, Rakhiya.
Next week, the 14th is the only date that it can be.
Then,
let it be 22nd.
हाँ, because I mean, 2 दिन नौचु तो सेटा 21 तारीख रखी दें.
22 रो 21 रे या 100
22 हाँ 22nd. So this matter on 22nd.
I pray, my lord, I had cited on that day one decision. This July part I had cited before your lordship. This July
on this point
regarding evidence which my learned friend
no, that's a different evidence.
Appreciation of evidence cannot be
no, that is another factor.
So my point is, my submission before your lordship is, I have relied on the decision of this Neeraj Datta in my objection. I want to only add this decision, July part 91.
No, Mr. Das will hear on the matter finally, just about this particular legal point.
Yes, ma'am.
Suppose I hold that, yes, let us say that this conviction is not likely to be sustained. Then whether I can suspend the conviction.
Exactly, ma'am.
Number one. And if conviction is stayed, then what benefit will get? Because he has been already released on bail, fine amount has been stayed, whether he can get the benefit or not.
Okay.
Because you see, recently the development has been made in Rahul Gandhi's case.
Yes.
Right. So on the basis of that conviction, right? So he was from the Lok Sabha membership, he was removed.
That is Panchayat, the People's Representation Act that was considered.
I'm telling you that like similar thing, whether there is any decision on this point by either by the Honorable Supreme Court or by this court or by any other High Court. Such stay of conviction is made. Somebody has been dismissed from service.
Whether he can be restored.
Right. That is.
No, I only pray before your lordship that besides this Neeraj Datta's constitutional based decision, which has been held, that in the event the complainant turns hostile or died,
disputed at all.
or died. So I am submitting one line.
So time I don't understand.
I
Your
there is
lordship
no
has adjourned it to the 22nd.
Mr.
Require my learned friend to make submissions.
So it will come on 22nd
Yes.
August 2020. Yes.
And my
Yes.
learned friend may
Why is he holding other people up?
Yes.
so may I request my learned friend to supply the copies of deposition which
All copies, my lords, all copies of depositions, they are served on the public prosecutor and the vigilance prosecutor.
No.
So Mr. Das will ask his client, the vigilance department, to supply him copies. I am not required to supply him copies.
All right. You find out your own, or if you want, that court can help you. But I am again, and I am telling you, when you are preparing this objection,
yes, my lord,
please don't say that you have not, because he must have.
No, he is bringing the officer who is swearing the affidavit.
No,
He is bringing the file along with him.
That is not the thing. Mr. Panda, when he has filed his interim application for stay of conviction, he must have said that in view of the evidence of so and so the conviction. So obviously you are to reply to each line that no, that is so unless you go through the evidence, how can you mention that? If you have not gone through, then your entire endeavor or whatever you have mentioned in the objection is maybe in a cyclostyle format. It
No,
is
my lord.
already.
Whenever the objection is drafted, my lord, the officer who has been authorized, he is bringing the entire file along with the deposition copies, etc.
Okay.
I am drafting and again returning the same.
Today we are rising early, Mr. Das. Today we will rise early.
Yes, ma'am.
So
On
please. Yes. Next.
Item number 27.
Lordship, last occasion, Lordship directed to deposit to file the deposition copy, but somehow there is difficulty for obtaining the.
You want time?
Yes,
Okay.
time.
Time allowed. Give another date.
It 1 week after, man.
Which one?
This one. So
Okay.
27.
Is it 1 week after? Yes.
Item number 28.
Wait, please, my lord. My lord, I have filed one interim application, my lord, for interim bail, my lord. And my lord, here the conviction.
There is no such application, madam, here. It's only IA for bail and IA for.
Yes, my lord, 1815.
Okay.
My lord, I have only received the IA copy. No criminal appeal.
No, my lord.
My lord,
that is for the
NCB, I am appearing for the NCB, my lord. I am for the virtual mode.
No. You have received the copy of the appeal memo and interim applications for bail and stay realization of fine.
My lord.
But what about this IA 1815?
My lord,
filed for interim bail.
IA 1815, I have already forwarded this application to the NCB department.
Okay.
Till yet, I have not received any instruction.
You want interim bail on medical ground?
Yes, my lord.
Who's
my lord, because the petitioner who is my lord, the appellant number 3 is suffering many difficulties in prison, my lord.
No. Where have you stated that difficulty? Obviously, prison is not a house where you can taste comfortably.
No, my lord, I bow down, my lord, but he's having some severe ailments.
Where have you mentioned it?
My lord, at para 10, my lord.
Para 10.
Yes, my lord.
Oh, no medical document, only
nothing. Severe ailment for.
Called for, my lord.
What severe ailment?
My lord, he is suffering from.
No. When you are filing a petition.
Yes, my lord.
And mentioning that he is suffering from severe ailment, is it sufficient that you will just mention like that? You will not obtain any instruction what sort of ailment he is having, what sort of problem he is having.
My lord, therefore I have prayed before your lordship to call for the reports, my lord.
Already you call for that health condition report.
I have already forwarded this copy to the NCB department, but the petitioner has criminal antecedent. Criminal antecedent.
No, it's all right. We are not deciding today. We just take instruction on this. IN number 1815 of 2023. This is an application for interim bail. In paragraph number 10 of the interim application, it is mentioned that the appellant number 3, what is his name?
My lord, Brismohan Gupta.
Appellant number 3,
Yes.
Brismon Gupta, is suffering from severe ailments for which he needs to be diagnosed with immediate effect. Land Counsel, Mr. Nayak, appearing for the NCV, submitted that he has received the copy of the interim application and forwarded the same to his department for obtaining instruction. Let Mr. Nayak obtain specific instruction on paragraph number 10 as to whether these averments are correct or not, and if so, whether the jail superintendent has taken any step for the treatment, diagnosis and statement of any ailment of the appellant. Is this matter in the week commencing from 21st of August 2023.
Kindly on 28, my lord. It will take time, my lord.
Which jail is languishing?
My lord, he is just HON'BLE. And NCB officer.
Why so much time? Today we are on 7th again. Yes.
My lord.
21st. 21st August. Yes.
Item number 29.
My lord.
Which order?
Previous order, my lord, order number 4. Order dated 17th July of 2000.
There is no order number 4 here. Only order number 1 is there. Where is the other orders?
Yes, sir. Your lordship called for the Yes, did your lordship call for the antecedent?
Yes, Mr. Tripathi.
Yes, Lord.
Any criminal antecedent?
No, Lord. There is nothing.
Okay, if there is no criminal antecedent, then let us come to the judgment. What is the conviction and what is the sentence?
My lord, the learned court will convict the appellant under 326 and 307.
What is the operative part of the judgment?
26, 27 and 28, your lordship. Yes, sir.
Okay, thus in view of my discussion, I found the appellant, this is Prashant Das. Yes, guilty for the offense punishable under section so and so. And sentence part is
28 and 20.
okay, that is RI for 7 years, fine of rupees 5,000 under 326.
And RI for
Then RI for 7 years,
5,000 in
5,307. and run concurrently. So it is 7 years, right? You were on bail during trial?
No, my lord. Since 20 November 2019, the appellant is in judicial custody.
So that means
He
you
never
have
applied
already
for the bail.
undergone 3 years and
3 years, almost 3 years and 10 months. 9 months, sorry, ma'am.
9 months. Oh, 3 years, 9 months. 1 plus 7. 8 months total complete. 8 months. 7, 3 years, 8 months. Yes, and who is that injured? What sort of injury he has sustained?
Kindly have a glass of PW2 first.
Is he?
PW2, eyewitness.
Trial court record টা trial court record টা দাও। আচ্ছা, PW2. Yes, PW2 কোন?
Yes, madam. I know the informant of the case. I know the accused standing there. I also know the injured of this case. He is the Ramahari Dalai. About 2 years ago, at about 2 p.m., the incident took place in front of the rest shed of our village, Chowk. I was present at the Chowk. I had seen the accused inflicting a blow on a head of injured by means of iron rod, causing bleeding injury on his head. The injured lost his sense at the spot. The accused even thereafter assaulted the injured. I and other called the ambulance and shifted the injured to Hinjilikatu. Thereafter, I returned to that. Then came to PW7, the injured. Yeah, PW5. Sorry, 7.
7 is the
7. The witness Ramahari Dalai, so on, witness box duly identified the additional PP, C. Ramachandra Chaudhary, as well as the wife of Ramahari, namely Mami Dalai. The learned PP, though asked the witness to disclose his name and identity, but the witness failed to answer and found he is unable to say anything but howling, and his condition inspired the belief that his mind is not functioning, maybe due to shock. The learned PP showed the head of the witness to draw the inference about the injury sustained by him on his left side head as well as the fatal area of the head, and there is clear mark of surgical operation on his head. There is also cut mark on his left ear of the witness. It is submitted the learned PP that the witness even unable to put signature, though he has earlier able to sign and disclose that due to incident he also lost his ability to write. And then came to PW5 Miller, the doctor. I was working on the consultant neurosurgery care hospital Bhubaneswar on that day. One patient, namely Ramahari Dalai, aged up to 50 years, went to hospital, and an emergency patient who was later shifted to neurosurgery ICU. And on the same day, I conducted emergency neurosurgery on the patient. Prior to the patient was earlier undergone treatment MKCG. Barampur. On my examination, I found the patient was unconscious, having multiple injury on his head, lacerated injury in size 5 cm over left temporal parietal region, another lacerated injury left eyebrow, another lacerated injury so and so to left temporal parietal region, incised wound over 3 cm to cm over left ear. The injury are earlier stitched by the medical officer and patient earlier got treatment. All 4 injuries were grievous in nature and might have been caused by hard and blunt object. And also advised CT scan of the brain of the patient according to CT scan of the brain conducted. After going through the CT scan report, I found intraperitoneal hemorrhagic constitution with mass effect of medullary sheath of 4 mm to right side of the brain. Subarachnoid node hemorrhage over left total left parietal.
No, Mr. Tripathi, you are right that the eyewitness has stated about the assault. Doctor also found number of injuries and even the condition is such that he was not in a position to say anything.
Yes.
Even he cannot write also.
Yes.
Right?
Yes.
So that is his condition. That's one side that is ultimately to be decided. We are at
Better
the
is the
stage of...
death. Better is the death. Better is the death, Miller.
No,
If he will die,
that's all right. But 7 year sentence is imposed.
Yes.
It's an appeal of the year 2023.
Yes.
And if he is not released on bail, he has already undergone 3 years, 8 months of sentence.
Yes.
So what will happen to is this appeal ultimately if he undergoes all the entire sentence? So that is what I'm asking you.
Yes.
Are the learned counsel for the petitioner, learned counsel for the state? The learned counsel for the petitioner submits that out of 7 years of the state should come up in such type of a case for enhancement of sentence, not that you will just sit idle and say like that. What would be the appropriate case then? You suggest your government to come in such type of cases for enhancement of sentence. There is a provision out of 7 years of sentence. He has already undergone 3 years and 8 months of sentence. There is no chance of early hearing of the appeal in the near future, and balance of convenience is in his favor. He further submits that the injured has not stated anything against the petitioner and good chances of success, and therefore the bail application may be favorably considered. Land counsel for the state, on the other hand, placed the evidence of PW2 with an eyewitness to the occurrence. So also the doctor, bracketed PW5, placing the evidence of the injured, bracketed PW7. The learned counsel argued that in view of the impact of the blows given by the petitioner during the course of occurrence, the vital part of the body, the witness was not able to say anything, and his mind was not working due to shock, as noticed in the depositions. When a query is made to the learned counsel for the state that whether there is any proposal of the government to file any application for an appeal for enhancement of sentence of the petitioner, he could not give any satisfactory answer. Be that as it may, considering the submission made by the land counsel for the respective parties, sentence imposed by the London trial court, period already undergone by the petitioner in judicial custody, absence of any chance of early hearing, I am inclined to release the petitioner on bail allowed.
Gratefully.
Stay realization of fine. Yes. Mr. Tripathi?
Yes, ma'am.
We have a function at 1 o'clock, so we are rising. But today there will be no further.
For lunch, 9.
There are so many
tomorrow rest of problem.